Good afternoon, everybody. Thank you for joining us today for the final session in our 2024 Professional Advisor Speaker Series. I want to extend a warm welcome to all of you and a special welcome to our speakers, David Khanjyan and Michael Rosen-Prinz, both at Loeb & Loeb. You should have received their bios and outline of the talk earlier today. But before we go any further, I just want to extend a warm welcome to our speakers and thank them for taking the time to prepare and present today. When considering a donor-advised fund, we know you have many, many choices. We really believe that our experience with nonprofits and the Jewish lens we bring, especially now, is an important piece and added value to our clients. Please take a minute to watch this short video that will give you a glimpse into why we're a trusted partner for philanthropists across Los Angeles.
I've been involved in lots of organizations, so I've looked to the foundation to help us get funding over the years. And so I've got this unique perspective to be both, I guess, a grantee and a grantor. I bring with me the perspective of being a person who came here looking for money over the years. And I see the process they go through in terms of vetting us, who's on board, the plans, the goals. They're very detailed in terms of the information they want before they give any money out. So I know how tough they are. So on one hand, that's a hurdle for me to get over. And on the other hand, it's very reassuring because I know that I can trust them with my philanthropic dollars because they're going to do the same thing to everybody else. They put you through the ringer for a good reason. They want to make sure that those dollars that they invest are well spent. One of the wonderful attributes about working with the Jewish Community Foundation is that we're on the same page. We have the same goals in mind. And so again, that brings another layer to the relationship. And so I trust them to make good recommendations for us and to look out for us. I feel lucky to be working with them because at the end of the day, we're doing our part in making the world a better place.
There are just a few weeks before year end. If you or your clients need to get a charitable tax break but don't know where they want to give, please give me a call. You can open a donor advised fund here, get the tax deduction, and give away the money next year or years in the future. Before I turn this over to David and Michael, I want to remind you to please send your questions to me using the chat function at the bottom, and we'll take them at the end. With that, I turn it over to our two speakers. Again, thank you for being here.
Great. Thank you very much, Steve, and thank you all for attending. It's a real privilege to have an opportunity to present to this group. I was just looking at the list of participants, and I see a number of friends and some very smart attorneys, and those categories are not mutually exclusive. But in any case, so David and I, we both work together at Loeb & Loeb, and we've done a lot of work with directed trusts here in California. So that's what we're going to speak to you about today. We're going to talk a little bit about directed trusts as a general concept, and then dive into the meat of the presentation, which is an overview of the introduced in 2024 California Uniform Directed Trust Act, and then talk about some of the nuances of California's new rule, and also how we're seeing these in practice, and just some open questions and thoughts. And I think, the really interesting part about these presentations are your thoughts and your questions. So please let me know. I can't promise that we'll have decisive answers to all of the questions that you raise, but we'll do our best. So with that, I do want to, just before we start, want to give a big thank you to another friend, Phil Hayes, who has been working with me on directed trust for many years and has been working on directed trusts and trying to bring them to California for over a decade. So he is responsible for some of the materials in here. If there's any typos, I'm certain they're his fault. But anyway, just want to thank Phil for that. So with that, David, why don't you talk a little bit about what directed trusts are and see how far you can get.
Thanks, Michael. Hi, everyone. Very happy to be here to present on the Directed Trust Act in California. Just to start, in terms of what the concept of a directed trust is, if we could first take a look at what traditionally how trusts were created. So under the unitary traditional model of trust, what you had is a trustee that takes title to trust assets and effectively administers the trust for the benefit of the beneficiaries. All of the powers and duties were effectively vested in this individual who is the trustee. Well, what happens if you want to bifurcate their roles? So you want Uncle Sal to take over the family business, you want Aunt Jamie to take over the marketable securities, and a third somebody else to make the distribution decisions. Under the concept of a directed trust, what you do is bifurcate these roles. And so you may have a distribution director who governs trust distributions and directs the trustee as to trust distributions, an investment advisor or director who makes decisions with respect to trust investments. And then that leaves effectively the trustee to follow the directions of the director and the distribution director and the investment director. And so aside from taking directions, then the trustee also takes responsibility for the more administrative tasks like filing tax returns, doing the accountings, and just back office work.
David, do you want to click through a couple more slides?
Yeah.
Here, so the whole idea, right, behind directed trusts is you're separating. Before we were you're limited by the tyranny of a single trustee who might be good at some things and not so good at others. Are you able to advance the slides, or are we
Yeah.
I don't.
Is it not
It's
moving?
not advancing for me. I don't know.
Oh.
Anybody else? I'm still seeing the first
Is
page. Okay, now it's
Sorry, it
gone.
was advancing on my other screen, but not here. Sorry about that.
Okay, no wonder you seem so self-confident in your
I was like, why
advancing the slides.
Okay, so
Perfect. Okay, so this is all that stuff. Great. So anyways, David explained, we're now saying instead of a single trustee exercising all the fiduciary powers and having all the liability, you can now separate that into someone just to hold title, the trustee, from the person or institution that is making the actual decisions regarding investments and distributions and anything else. And so why is this a great idea? Why do we care? Why do we even have a law about this? And really that's, in case you might have, first off, there are some people who are good at some things and not so good at other things. You might want to set up a trust and have someone be in charge of making distributions because they're kind and thoughtful and they know beneficiaries and they can really come up with the right amounts to distribute and how to do those, but is a terrible investor and you wouldn't want to have that person in charge of investments. You might want to have a corporate fiduciary, which has eternal life and is absolutely going to do everything right and will always be there, but perhaps you don't want them interacting directly with your family members, or rather making decisions affecting your family members. So you might want to have that corporate fiduciary act as a trustee, but not actually have to make these decisions. On the corporate fiduciary side, corporate fiduciary might be eager to act as a trustee, but may not want to take on specific liability or risk for certain types of assets. For example, if you say we've got to hold all Kodak stock in this trust, it might be difficult for a corporate fiduciary to feel that they are exercising their duty to invest prudently while fulfilling your desire to hold all Kodak stock. And that trustee might even say, I don't care how much liability you attempt to take away from me, and I don't care your attempt to indemnify me. I'm concerned that if you tell me you want me to be trustee and hold only Kodak stock, at some point there's going to be a beneficiary who said, well, that was a terrible idea because Kodak went bankrupt. And you really should have diversified into a prudently managed portfolio. And there's, a mountain of law saying that this is absolutely your fault, you bad trustee. And so you could have a situation where you've got the corporate fiduciary and then you get poor old Uncle Phil or someone like that, and they make the decision. They make the call to hold the Kodak stock, and they direct the trustee. And then the trustee gets to say, great, that's your call. I'm just following those instructions. And the good side for the settlor and the beneficiaries and everyone else is that typically when a corporate trustee does not have to undertake certain duties, they don't have the liability, they're not even responsible for the powers, then their fees drop. So you get this situation where you have a trustee that says, go, I'll take it, I'll be your directed trustee, and I'm only going to charge you the low fee of X $1,000 a year because I don't really have to do anything. But you still have the benefit of that professional trustee, and you know they're going to get the accountings on time, and you know Uncle Phil can't even do his own taxes, much less deal with the trustee accounting or the trust accountings. Okay, so great. So we have that's wonderful news. Why do we need a statute for that? Can't we write whatever we want in a trust? And the answer is yes, but what a directed trust statute does, in addition to creating some guardrails around how it works, and when you want to fight about it, you know, what you can fight about is, as it says in the bold language at the top of the slide, it reduces or eliminates the liability of trustees for following directions. And that is the magic of the statute. So if you take one thing away, the point of a directed trust statute is that when you set up this arrangement where a trust director or a trust advisor tells the directed trustee what to do, you have a statute that says, directed trustee, it's not your fault if they had a terrible idea, right? So that's what everybody likes about this. And these directed trust statutes have been around for many years. They, you know, before their statutes around in Delaware, you had common law directed trusts, which I understand came from the DuPont family saying, hold the DuPont stock, and the trustee saying, gee, I don't know, can we just push this liability and responsibility off to someone else? But there was then in the Uniform Trust Code, you had Section 808, which we'll get to a little bit later, which provided a directed trust statute of sorts. And then states went off on their own, setting up, with Delaware sort of the most prominent, setting up their own directed trust statutes. So states for many years have been focused on establishing directed trust statutes. Ultimately, the Uniform Directed Trust Act was promulgated by the Uniform Trust, promulgated by the, what do you call those people who come up with all the uniform acts? David, it slipped out of my mind. Quick, Google it and find out.
The Law Commission?
Yes, the ULC, the Uniform Law Commission. So, and now finally, California, new slide. Effective January 1, 2020. Nope, back one. Didn't we have something in there, SB 801? Or no, we're on, okay, perfect. There we go. So anyway, jumping ahead there, January 1, we've got the Uniform Directed Trust Act, but let's go back in history, jump back one more to California before that. So in California, much like in these other places, we did have directed trust, just casually done. You write it in the trust and everybody follows it. You write in the trust, you say, trustee, you're not responsible for making distributions. Somebody else is responsible for that. You're not responsible for making investments. Somebody else is responsible for that. That's fine. The issue that would come up, we said the magic of the directed trust statute is that the trustee is not liable for following directions. Without the statute, you could write everything you want in the trust that the trustee is not liable for following directions. But there is a question. If something goes wrong, would the trustee be liable for just following those directions? What if they were really, really bad directions from that trust advisor or trust director? Would the trustee be responsible, especially if you have a trustee that has really deep pockets, like a financial institution or a rich friend? It's unclear if they'd be, you know, again, we like to say that the terms of the trust govern, but there are a lot of talented and wily litigators out there who would take that case and say, trustee, even though this instrument says you're not responsible, the word trustee fills people with confidence, makes people think that you are watching over their assets and you really ought to have done something here. So there's one case from about the time I was 4 years old in Crocker Citizens Bank versus Younger, in which you had a situation in which there were multiple trustees, and the court found that the trustees and somebody did something wrong, and the court said, well, you know, one of you trustees, you had the duty to keep an eye on that other trustee. You had a duty to monitor, but it notes in dicta, had the trust instrument clearly spelled out, one trustee is responsible for this thing, and this other trustee is responsible for the other thing, and the trustee responsible for the other thing made a terrible mistake. The trustee responsible for this thing, the first thing, It's really not your you're not liable for the other trust responsibility had the trust instrument bifurcated those duties and responsibilities. And so from that flimsy piece of dicta, I think everyone knowingly or unknowingly has done California directed trust without any sort of statutory cover. And I'm not aware of any California case in which this has been challenged. And I have a lot of colleagues who say, hey, there's really no cases in California that ever show a trustee's been blamed for some other trustee messing something up when the duties were segregated. But I also know that I've never encountered a corporate trustee that's willing to act as a directed trustee without the power to make decisions and take actions out of fear that they might still be responsible for that. So, okay, so we have a problem. People are too cautious. They don't want to set up these directed trusts, which we think can be pretty helpful in the right circumstances. And now let's jump again one more slide. Enter the California Uniform Directed Trust Act. This has added some sections to the probate code. It was effective January 1, 2024. It's effective on a go-forward basis. So if you had one of these rogue, non-statutory based directed trusts in California before January 1, 2024, no one's saying you can't do that. You just can't point to the statute for anything you did before January 1. But now we've had a year of this new statute. Who knows? I don't know if a lot of people have been drafting these. I've done a couple of them. Of course, directed trusts exist outside of California. We'll talk about how that looks in some other states a little bit later in the presentation. But in the case of directed trusts in California, this new statute, it applies to trusts wherever they're created, as long as they have a principal place of administration in California. And the statute even has a safe harbor of how you would determine whether or not it has its principal place of administration in California. Maybe we will get to that later, maybe not. But David, we've teased this up for too long. Why don't you tell us all about this statute and what this new law says?
Thanks, Michael. So now let's just take a deep dive and look through the actual California statute to see how it implements the directed trust provisions. So section 16608 generally provides that the trust may grant a power of direction to the trust director. Generally, power of direction is any direction that any power that is exercisable while not acting as a trustee. And as you'll see later, the actual power of direction and the trust director is treated as a fiduciary. And so per se, any power that you give them will fall within the scope of fiduciary duties, with the exception of certain enumerated powers that are listed in the statute that I list over here. So a power of appointment doesn't fall within the scope of the statute. The power to appoint and remove trustees, the power of a settlor to revoke a trust, and the power over a trust if the terms provide that the power is exercisable in a non-fiduciary capacity and is necessary for federal tax purposes. So the one example in this context is really the swap power for grantor trust purposes. That's exercisable in a non-fiduciary capacity, and so long as the trust provides so, it's not technically considered a power of direction for purposes of the Directed Trust Act.
And David, can I pipe up real quick here?
Sure.
Just some color. So I think, the idea behind this power of direction is we are talking about fiduciary powers. This is a situation, this act is about splitting up fiduciary powers and the duties and liabilities that go along with having that power, and it doesn't affect powers that are non-fiduciary. And so the list that they wrote out in the statute, are generally powers that are not held in a fiduciary capacity, a power of appointment. Now I know, I've seen trusts before, I may have even drafted them, in which the trustee has a power that is deemed a power of appointment, an overriding power of appointment. That's still exercised in a fiduciary capacity. I think that's really just a gussied up distribution power, that's made to look fancy and given a different name. So maybe the trustee has to think extra hard before exercising it. But the power of appointment that we're talking about here is a true power of appointment that is almost always is held by a beneficiary and is in a non-fiduciary capacity. Same thing with appointing or removing, right? These are non-fiduciary powers in every instance I've ever seen them. I guess you could conceivably give someone a fiduciary power over that. settlers power revocable trust, doesn't owe any fiduciary duties. And then, of course, that, administrative power under Internal Revenue Code 675 that, we almost always see as this power to swap assets, which must be in a non-fiduciary capacity to qualify there as a grantor trust trigger. So really, I think what to take away from this, rather than running around memorizing all these terms, is fiduciary powers are subject to this act. And if you are giving someone a non-fiduciary power, someone is not a fiduciary, and we'll get into that soon about the requirement to be a fiduciary, to be a trust director, then it's likely not covered by the act. That doesn't mean it doesn't work, just means that it may not fit in as a directed trust.
Thanks for that, Michael. And then on the other hand of it, right, so once you have a trust director who has these powers and is per se a fiduciary that has all these obligations, well then the trustee is supposed to take directions from the trust director. And there are a host of provisions in the statute that I outline here that relieve the trustee of liability, except in the context of where the trustee would effectively engage in willful misconduct. And so it increases the threshold of culpability before a trustee can be held liable for following the directions of a trust director. And so just going through the statute, 16614 provides that the directed trustee is required to take reasonable action to comply with the trust director's directions, and is not liable for such action unless the trustee would, by complying with the direction, the trustee would engage in willful misconduct. Just to take a pause here to talk about what willful means. In the California context, the California trust context at least, there's no express definition. I spent a little too much time looking in the personal injury case law to try and figure out what willful misconduct may mean. I pulled out a rule statement from one of the cases, Calvillo Silva v. Home Grocery. And so in that snippet, they provide that unlike negligence, which implies a failure to use ordinary care, and even gross negligence, which connotes a lack of care as may be presumed to indicate a passive and indifferent attitude towards results, willful misconduct is marked by a mere absence of care, is not marked by a mere absence of care. Rather, it involves a more positive intent, actually to harm another or to do an act with the positive, active, and absolute disregard of its consequences. So just looking at face value, it requires abhorrent conduct on the part of the trustee where they have some express intent or malicious intent in taking directions from the trustee.
And that,
from the trust director.
Yeah, and what we saw here, right, when we looked over those cases in California, for whatever the case is, a lot of them are like cases involving people in cars and drinking too. A lot of drunk driving cases and like vehicular manslaughter. And it wasn't just maybe you had one too many and thought you could drive home. It was like you knew, and you were like drinking a fifth of rye while driving down a parade ground. Like, it's really willful misconduct, really, really bad. Not just like I'm not sure one or the other. So that's what it's trying to get across. And in thinking about, so here's another state with a directed trust. Another state with a directed trust act is Delaware, and Delaware has had the opportunity to look at willful misconduct. David, am I stepping on a later slide if I talk about Delaware's willful misconduct here? Oh, okay, right. So in Delaware, right, Delaware says, willful misconduct is intentional wrongdoing, not mere negligence, gross negligence, or recklessness. So it's worse than negligence. It's worse than gross negligence, which is like really bad. It's worse than recklessness, really bad. And when we talk about wrongdoing, they define it as malicious conduct or conduct designed to defraud or seek an unconscionable advantage. So this is like lying, stealing, cheating, in the trust context, right? It's difficult to say in the trust context how you're going to cause people physical harm. But this is like you are doing something you know is wrong and you are doing it anyways. So that's sort of what we've got in our heads, right? This statute hasn't been around hardly long enough for people to draft too many trusts, and barely not long enough, I expect, for anyone to take a lot of actions as a directed trustee. But I feel like absolutely hasn't been around long enough for anybody to sue anyone over the California directed trust statute. So I'm sure over time, as I said, with this bar of talented and wily litigators that someone is going to come up with a way about how like making a distribution 10 minutes late was clearly willful misconduct. But so I'm very eager to see how that plays out. But it seems like what it really should be is like really bad stuff that is bad. And I think, just getting back, and to overview, right? I mean, the trustee, ostensibly, their only responsibility here, if they're directed, is just take reasonable action. Like they tell you to do it, seems reasonable, do it, and don't do it if it's like horrible, like stealing. Right. And if you're not sure whether like maybe shifting your investment allocation away from, I don't know what it's supposed to be, 60% equities, 40% fixed income. Like if you're like, I don't know, 50-50 might be willful misconduct, who knows? Then you got this wonderful section, right, in 166.14d, go to court and petition. Right? Go and ask, is it willful misconduct if I shift my investment allocation a little bit because the investment director told me to do it? You go ahead and do that. I'm sure you'll annoy everyone by running to court to petition them all the time. But you know what? I mean, that's what everyone gets if you have an investment director telling you to do crazy stuff like that. So this is the playing field. I think this is the most important thing. I think this is what everybody's thinking about when they're deciding whether or not they want to act under a directed trust structure is how are we going to be responsible? And the idea behind this is you want to create a little bit of liability here. The trustee's got to pay a little bit of attention, but for the most part, let's let the trust directors work and the trustee can just hang out and execute those orders.
Thanks. And Michael, just to add some more light on the cases, of course, until we have some guidance in the context of trust, we just don't know. The one case that Michael was talking about was Williams v. Carr, where there was a drunk driver who was awake for 20 hours, had countless beers, fell asleep on the wheel and crashed, injuring the passenger. And in that case, they did find that it was willful misconduct. But on the other hand, there was a construction default case where the construction project collapsed and killed some employees and bystanders, and the manager was not held to have acted with willful misconduct because he did not know that the structure needed support and didn't know that it was compromised. And so if you could tell me the difference between those two cases and why they have different results, it's not clear to me. And it's even less clear how it would be applied in the trust context.
Yeah, so basically it seems to me it connects a lot to that knowledge, that willful misconduct. You had to know it was wrong and do it anyway. Not like, I don't know, I think it might be wrong. But like, you got to know if you're up for 20 hours and drink a case of beer and then go for like a pleasant drive, like that's wrong. You know it's wrong. All right, what about the trust director? They've got to be responsible for a bunch of stuff then if we've taken almost all the responsibility away from the trustee.
Right. So the purpose of the California Directed Trust Statute, on the one hand, is to relieve the trustee from liability for following directions. But on the other hand, is to fill the void and to keep somebody on the hook in terms of who the actual decision maker is. And so the provisions that I outlined here effectively put the trust director in the shoes of the trustee. And so the same fiduciary duties that typically apply to the trustee now apply to the trust director. The terms of the trust may vary the trust director's duties or liabilities to the same extent that they could be varied for the trustee. So under current California law, you cannot exculpate a trustee for gross negligence or more culpable conduct. So similar limitations will apply to the trust director.
So that means pretty much negligence, right? That's the only thing you can exculpate.
Right. So you have to stop at negligence. And then just in terms of when you need to bring a commencement for breach of trust, the provisions in terms of accepting, giving bond, all these provisions that typically apply to the trustee similarly now apply to the trust director.
Yeah, I just jump back real quick and just one thing in kind of, in getting this statute in shape. I mean, the objective was to put the trust director in exactly the same position as the trustee. And in pulling together all these statutes, right, we tried to do that. If anybody has figured out a place where you feel like the trust director is able to do something that the trustee is not able to do, or is more responsible or less responsible, or there's something that's missed, please let us know, because that was not intentional. So I think everything's been covered. Important to note that section 300 at the bottom, very important. trust company can act as a trust director, right? That red language is the new language that was added to section 300 at the bottom, and going through those other ones, right? You can sue a trust director for all the same stuff. They can defend all the same stuff. It's all should be the same for the trust director. And this was something, in California, unlike a number of other states where they seem to pass laws very easily, willy-nilly, in California, it's very hard. I mean, on one hand, you have a legislature that really could care less about most trust and estate stuff unless it's a conservatorship rule and they're worried about Britney Spears and Casey Kasem. But for trust stuff, like, our legislature doesn't know about trust and they don't care about it either. But there are these people, right, who work for the legislature, who are these attorneys, these legislative advisors, and most of them hide out in the various judiciary groups, judiciary committees, and they are sort of the guardians of California. And they really want to make sure that none of these sneaky laws that come out benefiting lawyers and rich people and trust companies, that none of them are disadvantaging the poor, hapless, orphans and widows and widowers and pensioners and people who are stuck. So they look very carefully to make sure that you're not somehow letting someone get away with something terrible. So it's very, very important to them to know that someone's holding the bag. The trust director is holding the bag for whatever they do. And they were all very pleased to see that through the addition of this reckless misconduct, even the trustee, who is exculpated from most of the liability in this case, still has a little bit of liability in that reckless misconduct standard. So if you turn it into an equation in a directed trust, net, you've got a little bit more liability for anything than a regular trust, because you've got the trust director on the hook for everything and the directed trustee on the hook for a little teeny bit of reckless, willful misconduct. All right, sorry, I'll get off my soapbox.
And then just to go on to section 16616, this is an information sharing provision. So where there's information that's reasonably related to the duties of both a trustee and a trust director, they're required to share that information with each other so that they could adequately perform their duties. But very importantly, section 16618 adds a limitation that provides that the trustee need not monitor the action of the trust director in taking directions, and is not required to inform or give advice to the settlor, beneficiary, trustee, or other trust director concerning whether the trustee would have acted differently. The genesis of this provision is a Virginia case, Rollins v. Branch Banking Trust. It's a notorious case because the idea of this case was, well, it was a directed trust where the investment director gave the trustee direction to invest in a very concentrated position. And the court held that, well, you're protected against liability for taking the direction because it's a directed trust. However, you are liable because you really should have notified the beneficiary and you should have warned them. And in order to prevent that back-end liability, directed trust statutes now include this provision that does not require the trust director to go and tattletale or inform the beneficiary that they would have done something differently.
Yeah, that's great. And so all of these directed trust statutes, in light of that Rollins case, they'll include this, because having that duty to warn, right? If the trustee has a duty to warn, well, it's like every single time they'll say, yeah, no problem, you did whatever, but you should have told everyone what a lousy idea it was. At the same time, the duty to provide information is really important, because what if you have an investment director and a distribution director? Well, and a trustee. Well, the distribution director probably needs to know from the investment director, are they going to have cash available to make distributions? And vice versa. Is the investment director needs to know, are they going to need cash to make distributions? So they do have a duty. These various parties in here that have these different duties must talk to each other, because again, before, in this unitary model of a single trustee, it's all just inside the trustee's head. And the trustee should know, while we're managing the assets, got to get the money out for Christmas gifts or year-end distributions or whatever else. And, look, we're all in private equity. Guess we won't see all our money for many, many years, right? They know it all. But here you've segregated these duties, which may be very closely, the objects of those duties may be very closely related to each other. So they have to talk to each other. They have to talk to each other. And the good news, right, you've got this beneficial relief of liability for reliance. If somebody tells you they're going to have the money, it's not your fault for committing, to make a distribution or doing whatever in reliance on the other fiduciary's statement about what they're going to do. Unless, of course, that reliance would be willful misconduct. And I'm not sure how you get to willful misconduct in reliance on somebody else's statement. I guess probably involves a lot of like winking and nudging in the side and knowing that they're, what they're saying is like crazy, but you're just going to rely on it anyway. I'm not sure, but got to put that willful misconduct outlier culpability in there regardless.
And then just a few additional catch-all provisions to close out the statute. So 16608B provides that the trust director has any further powers to help execute their duties. This is similar to the trustee where they have a host of powers that will help them implement their responsibilities. And then importantly, under section 16620, the statute extends to application between co-trustees. So prior to the statute, when you had co-trustees under California law, they did have a duty to monitor each other, and to the extent that one committed a breach, the other was responsible to take reasonable action to redress the breach. Under the statute now, you can bifurcate the roles among co-trustees, so you could have one trustee responsible for certain items, another trustee responsible for others, and insulate them from the actions of the others. Another takeaway from this provision is, again, that labels don't really matter. You could call somebody a trust director, you could call somebody an investment director, distribution director, the business trustee. It doesn't matter what you call them, so long as you appropriately include the provisions in the trust instrument, it'll govern under the statute.
Yeah, and I guess just one thing about this 16620 section here, I think this is really helpful. I mean, on one hand, it's nice because this goes all the way back to that Crocker Citizens Bank versus Younger thing, right, where you did have a couple of trustees and this concept of having segregated duties. So what this means is, I mean, you can have an investment trustee and a distribution trustee, and they, as long as their duties are clearly spelled out and separated, they're each responsible for it, and neither is their respective brother's keeper. What also I think is really helpful about it is you don't need to set up a sort of stilted structure of having one trustee direct the other and the other trustee do it. I mean, you can just have two trustees. They both, they're co-trustees for purpose of taking title, but their duties are segregated and either of them can act. You probably would have the trustee with the investment powers be the one, and you would clarify this, be the one to be on title. But you would need to ensure that the distribution trustee had the ability to directly carry out a distribution with that bank account. And that's the sort of, practical hand-wringing thing that you can sort out with the custodian of the assets. But it's nice, I think initially we thought, well, we're going to have a situation where you have one trustee directing another trustee, and you've got to run around with these like instruments of direction all the time. But here you can just have two trustees together. However, it is important, David's right, the names don't matter, but for one thing, you need to clarify whether someone is a genuine trustee, capital T, right, as that would be seen under the act, or are they a trust director? And you can, if they're a trust director, you can call them a trust advisor, you call them whatever, but just make clear that their only power is to direct a trustee to do something, as opposed to in the co-trustee situation where each trustee, is actively doing the action, not just directing someone else to do it. So when you're drafting, and I don't think there is a uniform or a model form for any of this, a lot of this is really what situation you're in and why you need this. And so you would need to draft to suit that. But there is the decision point there. Are you doing a directed trust where you have a trust director directing the trustee to do something, or do you just have co-trustees with segregated responsibilities? Okay, so what's not in the act that might be in other acts? Well, I think one of the main things is the act doesn't have a list of all the duties that trust directors might have, or these categories of directors, like you may have an investment director, you may have a distribution director, you may have a tax director, you may have a notice delivery director. You may have, you can really take sort of any power, you could make that a You could fit that into a directed trust category. You just need to have in your instrument, make it clear what the trust director is responsible for and what the trustee is responsible for. Similarly, there's this issue of stuff that falls in the middle, and here's a couple of good ones. I mean, one, a loan to a beneficiary. Is that an investment that an investment director would be in charge of? Or is that more like something that a distribution director would be in charge of? Typically, a loan to a beneficiary is not the type of investment that anybody else would want to make. It's oftentimes done at a reduced rate of interest at maybe the AFR or sometimes even for no interest. So you make this loan to a beneficiary. The terms are often not market. Usually there's no security. Is the investment director the one who decides whether to do that? Or is that more like a distribution that we don't want to have the tax effects of a distribution right now? So maybe the distribution director is in charge of that. That is something to spell out in the trust instrument specifically. Similarly, let's say that there's an investment goes wrong and you need to enforce that, that investment contract. You need to foreclose on a loan. Is that something that the investment director deals with? Does the distribution director deal with it? Is this a power that's left to that poor directed trustee who is getting paid $5,000 a year and really doesn't want to do anything unless they're told to? I don't know. What about initiating litigation? What about settling litigation? So it's important to think through the things that a trustee does. And we normally think about trustees investing and distributing, but there are a lot of other rights and powers that go along with owning property and being in legal arrangements. And so it's important to decide who has those things. And will it be one of these trust directors? Will you set up a third trust director to deal with those? It's really up to you and to your situation. So California, in this case, California kind of limping into this race. 47 states. We are 47, I believe. Might be a couple other out there, but not all the other states that have directed trusts do them the same way. Included in this list are trusts that have just adopted the Uniform Trust Code. And as I mentioned before, in Uniform Trust Code section 808, it talks about the ability to have a directed trust and the degree of liability for the directed trustee when they're directed to do something. In UTC section 808 says that the trustee shall act in accordance with an exercise of the power unless the attempted exercise is manifestly contrary to the terms of the trust. So this means that in a Uniform Trust Code section 808 state, right, where that's the only directed trust act that they have, the trustee needs to make sure every time they're told to do something that what they're being told to do is not manifestly contrary to the terms of the trust. That doesn't mean they have to have any particular standard. I mean, that seems like absolute liability. If you're told to do something and the terms of the trust say don't do that thing and you do it, it seems that you're breaching your duty as a directed trustee. And what that means, these trustees actually have to read the trust and they have to know what they're doing. And for most directed trustees, like that's a bridge too far. They're like, yeah, I'll be your trustee, but don't expect me to know what's in the trust and whether or not I'm doing it. I'm just here to sign the papers, especially sign my own check, right? So UTC, not a great place for trustees. I don't know a lot of financial institutions that are really, really eager to act as a directed trustee in UTC section 808. So this is like Goldilocks, right? Like, oh, too risky. We don't want to do it. Well, there's some other states out there, and like New Hampshire, I believe, Wyoming, or maybe I'm just tossing out names now, where they're like, you don't have any duty. Don't even worry about it. Hey, do whatever they say. It's all good. It's all good. No liability. Back in 2010, the first time there was a run at having a directed trustee statute in California, that was the standard. No standard. Directed trustee, just following orders, I'll talk to you later because I'm not responsible whatever this crazy trust director told me to do. That seems, the other side of the Goldilocks paradigm, right? This bed's too risky. This bed's not risky enough. So willful misconduct is the just right porridge in the middle or the bed where you say, hey, you got a little bit of liability. Don't go crazy with it. But for the most part, you're all good. And that's where California is. That's where Delaware is. And that's where the Uniform Directed Trust Act is. The other issue is when you're looking at the trust director standard of conduct in California and with the Uniform Directed Trust Act, the trust director is a fiduciary. They have all these duties. There's another option in some of those crazy states. You can say that the trust director is not a fiduciary. So this is like an amazing magic trick here, right? You got a place where you say, let's take these duties normally held by a trustee or fiduciary, subject to fiduciary standards. Let's say the trustee's got no liability for following the directions of the trust director. Poof, that's great, right? We put the rabbit in the hat there. Now we say the trust director, who's responsible for telling them, trust director is not a fiduciary. Bam, pull the rabbit out of the hat in the other hand. It's like an amazing trick. Where's the liability? Who knows? It's like out the window. The trustee doesn't have it, just following orders. The trust director doesn't have it, not a fiduciary, right? I think that's crazy, but I guess some other people don't. And I guess you could set up trust there. Wouldn't want to be a beneficiary in those states. Of course, everybody's just doing their best, but it's tough without having this liability. Some people say if there's no liability, do you even have a trust? Maybe you just have some kind of nominee arrangement there. What about trust protectors, right? Trust protectors is one of these things where I feel like just whatever you say it is, right? California doesn't have a trust protector statute. Some people have trust protectors that are non-fiduciaries, that are like magical wizards that sail down from the sky and don't owe anybody anything and just change the trust, do whatever, claim not to be a fiduciary. Other folks will oftentimes use a trust protector as a fiduciary. They write in their document, the trust protector is a fiduciary, and they maybe are like an independent trustee or super trustee, and they can do things that maybe you think are like too crazy for a normal trustee to do. Sometimes they'll restrict decanting.
Sorry, I'm listening to something else. What 19
Could you
to
mute?
21? Those are the years we estimated.
Daniel, could you mute? Anyway, right, the magical trust protector's got all these amazing abilities. Trust protector may or may not fit into this statute. And rule of thumb, if the trust protector is a fiduciary and has a power of direction, they're actually a trust director under this statute. If the trust protector is something else, you got to figure out where that fits in. All right, next slide. So another kind of frequent thing, what do we need this whole directed trust thing for? We have delegation, right? Everybody knows about delegation. You're a trustee. You can delegate certain powers, right, to somebody else. And oftentimes what will happen is a trustee will delegate their investment management powers over to someone like a registered investment advisor and say, hey, you're the expert. You go ahead and do that, and I'm the trustee. And isn't that the same thing as a directed trust? The answer, no, not the same thing. In delegation, the trustee has the power to delegate to someone else, but the trustee retains the duties. They have to select the agent, right? They still have fiduciary duty to select a good agent. You can't pick someone like me who'll do a terrible job. They need to establish the scope and terms of the delegation. Hey, you're going to invest this much money, and here's how we want you to invest it. Don't put it all in potato futures. They gotta pay attention to what the trust instructs them in terms of those limitations. And they have to review and monitor the conduct of the agent. To the extent they do all those things, they do not have the fiduciary responsibility for anything beyond those three duties. That is the day-to-day investment. So really, it's the trustee choosing to exercise those powers and still retains duty and liability for those three things we mentioned.
Michael, if I could add briefly here, because we got a question that touches upon this issue, and it was whether a current trustee who has generic powers has the power to appoint a co-trustee, can he now appoint a directed trustee with specific duties? And I think the answer is similar to the delegation. If the trust instrument doesn't provide separate duties, the trustee, when they appoint a co-trustee, they would be co-trustees for purposes of the code prior to the CUDTA. So the provisions wouldn't necessarily apply in a similar manner to isolate their duties. It would have to be the trust instrument that does so, not the appointing.
I think that's right. I think that you need to have something in the trust instrument that governs that conduct. Now, maybe you could say, could that trustee do a decanting, right? They decant the assets. could they decant the assets to a new trust that has a directed trust form? And that's, I think there's a possibility there, but you have this issue of, does that trustee have any liability for doing the decanting, which is limiting that trustee's own liability, which is a little self-serving. I think once you get over that hump, it can work. And so just to round out this comparison here, delegation, trustee chooses to do it, retains certain core liabilities in the course of the delegation. In a directed trust, it's not the trustee's choice. It's just the rules of the game. The trust has this separation of powers. The trust has this separation of powers between what the trustee does and what the trust director does, and then they follow. So then in that case, the trustee has no liability for what the trust director does, except for that willful misconduct, in following those directions. So a directed trust situation is, I would say, a more powerful division of those powers than delegation. And in some cases, you may have the investment advisor or investment director directing the trustee to delegate those powers to someone else. And in that case, then the investment director is going to have those 1, 2, 3 fiduciary duties in the delegation section. So where do California directed trusts make sense? I think because you're generally going to have a more well-established, and we'll talk about this in a slide or two, statutes in other states with a lot of really great things going on there. No rule against perpetuities and silent trusts and virtual representation. I think we're seeing California directed trusts coming up with revocable trusts, people who want to have a revocable trust that after the settlor has died, the trust becomes a directed trust. Typically, those trusts are going to be under the law of the state where the settlor lived, which in this case is California. If there are only individuals and trust companies are not involved, I think trust companies are going to be a bit reticent to start doing California directed trusts when they have a lot of established law in Delaware and Wyoming and South Dakota and Nevada and other states like that. Or in low value situations where it doesn't make sense to move the trust to another state. So those are the cases where I think California directed trusts are going to be useful and commonly used. Now, let's say you have a trust in California. Next slide. You've got a regular vanilla trust, just like the one David was talking about, and you want to have a directed trust. How can you get your trust into directed trust shape? Well, you can decant into a new trust form. We have a California Decanting Act. This is great. However, one downside is you're very likely going to need to appoint a guardian ad litem because you will need to provide notice to all beneficiaries, and that will often include minor and unborn beneficiaries who need to be represented by a guardian ad litem. Similarly, you could modify the trust under our not quite non-judicial modification statute, 15404, where all the beneficiaries in the settlor can modify without a court petition. Unfortunately, there's that pesky all beneficiaries language, which really means all beneficiaries, even those minor and unborn. So there you are with the guardian ad litem. And if you want to go to court anyway, you could just do it in 15403, leave the settlor out, just have all the beneficiaries petition the court. And then finally, you can just move that trust out of California to another state that's going to have a non-judicial settlement law or an easier decanting rule, and then you could modify the trust then and perhaps bring it back to California. But finally, since you're going to other states, I mean, why do is this it? Do we still need to have trusts in other states? I think the answer is yes. There's a lot of great, super helpful and useful rules in these sort of lowest common denominator race to the bottom states that just get any law across that would be helpful to attorneys and trust companies. A lot of them don't have income tax, no pesky rule against perpetuities. This concept of the silent trust where you can name someone else to get notice and other information that should go to beneficiaries. You can kick that can of telling the beneficiaries what you're doing down the road for a bit longer. They've got these self-settled, irrevocable trusts for creditor protection. I think you're never going to see that in California. Virtual representation, fingers crossed, we might get that in California sometime soon. And then generally speaking, just kind of a more robust settlor and trustee friendly environment. So there's still, we don't need to cry for all the Delaware trust companies. I think they're still going to have a lot of business, but not everybody wants to go there. And for those people, it's great that we have this option now in California. So I think, David, unless anything else you wanted to add, we can take some questions. I do see one in the chat. And then Steve, I don't know if you've got any more.
David, did you want to add anything?
No, I think we could go to questions.
Okay, yeah. So there are a couple questions in the chat, which I guess you can see. So do you want to just take them, Michael or David?
We only see the one about that. I'll read it now. And it says, if an investment director or distribution director of a Nevada or Wyoming directed trust is a California resident, is the trust being administered in California if the advisor provides direction in California or outside California? I think, this is a little tricky. I mean, I think we go towards in the statute, and I don't have the site in front of me, but the statute has a very high bar for this sort of safe harbor of when the trust will be considered having its principal place of administration in California, and requires essentially everything happening in California and all the fiduciaries being in California. So I don't think California would assert that it's being administered in California unless you took actions believing that is the case. I think that your Nevada or Wyoming directed trust is for purposes of being a California resident trust and having this statute apply. I don't think California would assert jurisdiction. That doesn't necessarily mean that you are not subject in this case. Doesn't mean that you're free from California income tax. That's a separate issue. If you have a California non-grantor trust, whether or not there's California income tax on undistributed income, California has this rule where they typically look at the number of fiduciaries total and the number of California fiduciaries, and the trust is subject to California income tax on the ratio of the number of California fiduciaries over the number of total fiduciaries. And there is not a clear ruling how directed trusts work. I think a conservative point of view is just take each director and each trustee, that's the number of fiduciaries, and then the number of California people over it. So probably right answer is not California for purposes of having California law apply for administration and according to the California Directed Trust Act, but probably do have some California income tax. David, do you want to take the next one?
Sure. So does the California Directed Trust Law and protections for the trustee apply to pre-existing trusts executed prior to 2024 that segregated duties between trustees or attempted to segregate fiduciary responsibilities to non-trustees? The answer is yes. So they do apply to pre-existing trusts, but only with respect to decisions after the fact. So you can utilize existing trusts and fall under the statute and rely on the statute to protect the trustee from liability.
So yeah, it applies right after 2024, but not for past action.
Right.
Okay. We are coming right up on 1 o'clock. I just want to thank you both for the presentation. I'm so appreciative of your time and grateful to learn about this. You made it really easy to understand for someone who's not a lawyer like me, and I so appreciated the humor for a complicated issue. Made it much more fun to listen to. This wraps up our 2024 Professional Advisor Speaker Series. I hope that we have a chance to see each other before year end, but if not, please stay in touch. I wish you all a healthy and joyous new year. If any questions come up, we sent contact information for Michael and David earlier today, so please be in touch with them directly. I'm sure they'll be happy to talk with you about your clients. And thank you all for being here. Wish you all a healthy and joyous new year, and I look forward to seeing you again soon. Thank you.